Good afternoon, everyone. I'm Diane Hoffman. I'm a member of the faculty here at the Law School and director of the Law and Healthcare program. And I'm happy to welcome you all here to this year's Stuart Rome Lecture. And I'm especially delighted to welcome our distinguished speaker, Professor Hank Greely from Stanford Law School. But before I introduce Professor Greely, I wanted to say a few words about the Stuart Rome Lecture. The lecture was established 30 years ago, actually January 1984, to honor the memory of Stuart Rome. Stuart Rome was a Baltimore native and an attorney, a community activist, a patron of the arts, and a humanitarian. Despite a demanding career, first with the Office of the Attorney General and then with the Baltimore law firm of Venable, Bacher, and Howard, Mr. Rome dedicated himself to pro bono and volunteer work with a wide number of organizations in Maryland, including the NAACP, Echo House, which provides substance abuse treatment to adolescents and adults, the Mayor's Advisory Committee on Art and Culture, the Baltimore Association of Retarded Citizens, the Maryland State Arts Council, the American Civil Liberties Union, the Baltimore Jewish Council, the American Jewish Committee, and the Baltimore Museum of Art. Mr. Rome passed away in 1983, and his family and friends established this lecture in his memory, and we're very grateful for this gift. The Law and Healthcare program has used this gift to bring a number of distinguished speakers to the law school. Just a few of our past Rome lecturers have included Professor Lawrence Gostin from Georgetown University, Professor William Sage from University of Texas, Professor Robert Burt from Yale Law School, Nancy Ann DeParle, the former director of the Centers for Medicare and Medicaid Services, and Daniel Levinson, Inspector General for the U.S. Department of Health and Human Services. Our Law and Healthcare program, which sponsors this event, has been a pioneer in healthcare law since Professor Karen Rothenberg launched it almost 30 years ago. The program combines education and research on emerging medical, health policy, and legal issues. It works to address health law from both legal and interdisciplinary perspectives, often bringing together scientists, medical experts, legal experts, and social sciences to discuss cutting-edge issues in the law and make recommendations for change. Our Rome lecture today on neuroimaging, mind reading, and the courts is actually the kickoff to a roundtable being held tomorrow on imaging the brain, changing minds, chronic pain neuroimaging, and the law. This roundtable, organized by Professor Amanda Postelnik, who is on our faculty, along with Professor David Seminowitz from the Department of Neural and Pain Sciences at the University of Maryland School of Dentistry, and Mark Frankel, Director of the Scientific Responsibility, Human Rights, and Law Program at the American Association for the Advancement of Science, is an example of this effort to bring together an interdisciplinary group of scientists, medical experts, legal scholars, and judges to create a dialogue between these fields and explore the implications for legal decision makers of breakthrough work in neuroimaging that has led to a paradigm shift in understanding chronic pain. I know that a number of our speakers for tomorrow's roundtable are here, and I wanted to welcome you all as well. The Rome lecture and the roundtable tomorrow would not have been possible without the support of several individuals and organizations. In addition to the Rome family, I'd like to acknowledge and thank Alan Eason, who is here with us today for their gift, as well as the Reuben Schilling Mental Health Law Fund, the Leonard C. Homer Oberkeller Law Fund, and the Dr. Richard H. Heller Fund. I'd also like to thank Nadia Hay, the Managing Director of the Law and Healthcare Program, and Virginia Nadia, the coordinator of the program, and Virginia, the Managing Director, for their attention to all the details necessary to put events like this together. And now it's my pleasure to introduce to you our Rome lecturer, Professor Hank Greely. Professor Greely is the Dean F. and Kate Edelman Johnson Professor of Law and Professor by courtesy of Genetics at Stanford University. He graduated from Yale Law School and upon graduation served as a law clerk for Judge John Minor Wisdom on the U.S. Court of Appeals and for Justice Potter Stewart of the United States Supreme Court. After working during the Carter administration in the Departments of Defense and Energy and then in private practice at a law firm in Los Angeles, he began teaching at Stanford. He specializes in ethical, legal, and social issues arising from advances in the biosciences, particularly from genetics, neuroscience, and human stem cell research. He directs the Stanford Center for Law and the Biosciences, chairs the Forum of the Institute of Medicine and the Advisory Council for the National Institute for General Medicine, Medical Sciences at NIH, And from 2007 to 2010, he was a co-director of the MacArthur Foundation's Law and Neuroscience project. He is truly a leader in, and through his publications has made contributions to all the major issues in the law and neuroscience field. We are truly honored to have him with us today as our Rome lecturer to speak on neuroimaging, mind reading, and the courts. Welcome.
Thank you. Thank you very much. Well, I think it's my honor to be here at the feedback. It's an honor to me to be here at a presentation put on by the U.S. News & World Report #1 ranked health law program in the country. U.S. News & World Report is complete meaningless, and it's the best to say that when they rank you #1. So congratulations to Diane and to the program and to the University of Maryland. I want you to look at my sweater. How many different colors are in it? Count them silently. Now I want you to listen to my voice. Am I a tenor? Am I a baritone? Am I a bass? I'm not a bass. I want you to notice the feeling of the chair on your bottom. How it feels, where you feel it. Now I want you to wiggle the big toe on your right foot. Right foot, not left foot. Right foot. It's the left toe, but it's on the right foot. And now finally, and I probably don't have to ask you to do this, I want you to wonder, what is my speaker doing with this introduction? And the answer is all of those things that you did or perceived or thought or felt, all of those are, as far as we can tell, the product of the firings of some of the 100 billion neurons in your brain. Neurons give off packets of neurotransmitters, they pick up packets of neurotransmitters, they send ions cascading down the outsides of their membranes, and they create the universe in which we live. Now, I don't quite mean that literally. I do think you are here, and the building is here, and the universe is here. I think there is a reality out there. But my only interaction with that reality is through my brain. My only recognition, my only consciousness of the reality out there, or the reality of myself, is because of my brain and because of physical events that happen in my brain. Those physical events create a non-physical mental construct. But that construct is created by physical changes in your brain. If you remember tomorrow that I spoke today, it is because I will have made physical changes in your brain. Now that's kind of daunting, and when I first started working on law and neuroscience about 12 years ago, I fought back against it. But I've hung around with enough neuroscientists that I've come to accept it. I think it's true. I'm not entirely sure what it means, which is one of the reasons I love this field so much. But I think one of the things it means is as we get better at looking at those physical changes in the brain, as thanks to new technologies we can both see and interpret physical changes in the brain, we can begin to correlate them with mental states. We can begin to say, anytime you move the big toe on your left foot, neurons up here, on the left foot, okay, I changed feet. Neurons up here start to fire. And every time you see anything, a blue sweater or anything else, neurons back in your visual cortex start to fire. And maybe at some point, although I think not exactly yet, we may even be able to see from which neurons are firing which colors you're perceiving in my sweater. There's some spectacular work, now several years old, by Jack Gallant at UC Berkeley. He's a tried and true Stanford person. It hurts me to say anything good about UC Berkeley, but Gallant is a spectacular neuroscientist, and he did this amazing work taking a bunch of volunteers and showing them thousands of hours of YouTube clips while they were in a scanner, and analyzing their fMRI results in terms of what they were seeing at the time. Then he took new people, put them in the scanner, showed them film previews, and used those scanning results to recreate what they were seeing. If you Google Gallant and movies and MRI, this will come up. I recommend it. If I weren't so deathly allergic to PowerPoint, I probably would show it myself. It causes anaphylactic shock, I think, and would kill me. And I'm not willing to take that risk with respect. Either that or it's against my religion. Either way, I don't use PowerPoint. But there's an elephant walking across the plane from left to right in the movie. There's a haystack shaped like an elephant walking from left to right across the plane in the movie, in the brain scan recreated version of the movie. It's not perfect, but boy, it's pretty good. And it comes from correlating physical aspects of the brain with mental states. It is that and the application of that to law that I want to talk about tonight. Because I think what we are beginning to be able to do using neuroimaging is to read minds, is to look at physical changes in the brain and correlate them, not necessarily 100%, but in some cases very well, with mental states, and be able to say, he's looking at either an elephant crossing the plane or a big haystack crossing the plane from one side to another. Most of the attention in law and neuroscience has focused on issues of free will and criminal responsibility. Personally, I think that's a mistake, but I've found that philosophers in particular, neuroscientists to some extent, do not have free will to avoid thinking about free will. It is what they love, it's what they love to talk about, and as long as I don't have to pay too much attention to it, I'm fine with them doing that. But I actually think the important contribution, or the more important contribution that neuroscience will make to law, will be in mind reading, will be in its use to tell us, to give us more evidence about what people are thinking, what people are feeling. And I want to make that argument today in 4 parts. First, I want to talk about what kind of evidence we use to read minds already, and how and whether this is different. Second, I want to talk about some of the possible uses that the law could make of neuroimaging for mind-reading technologies. Third, I want to talk about what we would have to do if we were serious about using it well. What kind of investment we would have to make and what kinds of research and procedures in order to make this useful scientific evidence instead of poor scientific evidence. And last, I want to talk about some of the deeper problems, even if we thought it worked well, some of the deeper questions that lurk about whether we should use it, when we should use it, and in what circumstances we should use it. So right now, I think we are on the edge of this. As 2 of my former postdocs said in a article title, we see through a scanner darkly. We don't see clearly, but we see a little. And the visual acuity through the scanner, or at least our understanding of what it means, is getting better and better. And I think this is going to be a big question. And I compliment Amanda, who has been following this sort of issue rather than the criminal responsibility issue in much of her work on law and neuroscience. So let's start with evidence, and evidence of mind reading. I am reading your minds right now. I am, of course, reading your minds. You read my mind. We read our minds, each other's minds, all the time. You may not be looking for the same thing in me. I'm looking for you in you, who's awake, who's asleep, who's texting on their cell phone. Nobody so far, I think, or else you're hiding it really well. Who's confused, who's angry. Your speakers actually in a room like this especially can see you, and we actually look at your faces and we try to read your minds. And we read your minds by looking at your faces, by and large, in this context. A little bit of body language, mainly faces. If it's an interpersonal verbal communication, we'll listen to the tone of voice and how you're expressing yourself, as well as occasionally to the actual words you say. But we're reading your minds through more than just listening to your words. We read minds all the time. What we are doing, of course, doesn't give us any super special deep insight into what you're truly thinking. We're looking at outward manifestations and correlating them through our experience with humanity in general, or with you in particular. Every time Mark crinkles his nose like that, he doesn't like something, for example, correlating them with mental states in ways that we have come to know about. So we're using physical cues, in this case external, visible physical cues, correlating them with what we know about mental states and using them to read minds. We do this all the time. I think it is a deep human survival trait. I think it is evolutionarily encouraged and preserved because it's been a long time since we've had to worry more about lions and tigers and bears than we did about each other and whether this person is going to share his food with me or hit me over the head with a club. Being able to tell the difference between that is a really useful survival skill. And there are people who lack it. One of the great disabilities for many people with autism is that they don't have what the psychologists call a theory of mind, which has always been a term that's bothered me, but they don't have an intuitive feel, or they don't have a feel for what other people are thinking. Some of them, anyway. And that's a real disadvantage. I had a colleague like that once. He's not with us anymore. Anyway, he's at a different law school. He actually, so one of his few friends on the faculty said, I was complaining about him. He said, no, he's really a good guy. He doesn't mean to be rude. I said, how do you know? He said, because he did something rude, and I said, that was rude. And he said, really? Why? Explain it to me. Write down a rule, and I won't do it again. And he never did it again. But it didn't help him figure out other things that were slightly different that were rude. So I think reading minds is really important. We take it for granted. We do it. We learn it at an early age. We take it for granted. It's evidence we're using, external physical evidence, to try to get to subjective states. And of course, the law tries to read minds all the time. Was this premeditated? Was this with malice aforethought? Was this reckless? Was this knowing? Did you realize that the bonds you were trying to sell were complete junk bonds? Now, all those are sort of mental state questions. Juries sometimes have to answer them by looking at somebody in the eye and trying to decide whether they believe him or not. Other times we have other forms of evidence that we think correlates with it, like other statements that they made to other people that have been recorded, or various actions they did, like buying a one-way ticket to Rio the day before they got arrested. All these are some evidence of mental state, external evidence of mental state. I want to talk specifically, I want to move this now and talk a little bit about pain. Pain is not the only issue for which neuroscience lie detection, neuroscience mind reading will be really important, but it is, I think, one, and probably the one that will come to the fore first, and certainly will come to the fore first for us because tomorrow we have an entire day devoted to it. How do we decide whether somebody's in pain? Well, one way to do it, of course, is to ask them, are you in pain? And I think in most circumstances, if you want to understand somebody's mental state, and they're capable of communicating, so they're not asleep or unconscious or unable to speak in your language or understand or speak in your language, asking them is a good first start to knowing whether they are in pain or not. But it's not necessarily the end of the story, because sometimes people don't tell you the truth. As Hamlet said, there are men who can smile and smile and yet be villains. The fact that people don't always tell the truth, or sometimes they exaggerate, is something that we learn usually to our disadvantage very early in life. So what else do we look for? Well, if somebody's got a broken leg and the jagged remnants of one of the bone is sticking out through the bloody wound, and they're screaming like crazy as they're trying to hop down the street to get away from the exploding car they just got out of, that's sort of circumstantial evidence that would lead many of us to conclude, he's probably in pain. There's a very good chance that person is in pain, because we see a wound, we see a problem that leads us to think, hey, this is the sort of thing people would be in pain from. And he's screaming, and he's hopping, and he's trying to avoid putting weight on it. He's doing all these things that would lead us to conclude he's probably in pain. You see somebody limping, and the limp could be a non-painful structural deficit, but it could also be a result of arthritis or some other form of pain. It's a piece of external evidence about his pain. You talk to coworkers who say, pain? No, he never seemed to be in pain. We went out to the trampoline just the other night and spent the whole day bouncing up and down at the trampoline place. That's some external evidence about pain in the other direction. We use this non-direct circumstantial evidence to try to draw conclusions about somebody's mental state. Now, let me bring this back to neuroimaging. As some of the people who will be presenting tomorrow have done some of this research, others on the law side have written about and studied some of this research, neuroscientists are beginning in several different ways to think that they can see with neuroimaging things in the brain that correlate positively with the perception, with somebody's self-report of pain, and often with a self-report of pain in a context where we think it's reasonable they would be feeling pain, i.e. we've just smeared hot chili pepper powder paste on their hand, and we know people feel pain that way. And we see that either, in that case, there are different patterns of blood flow to different regions of the brain through what's called functional magnetic resonance imaging, and we see patterns of networks that get activated when people are feeling that kind of pain. You can also look at people who have been in chronic pain for a long time and see that the physical structure of their brains often has changed, that some areas of their brain appear to shrink. The longer the chronic pain, the more the shrinkage. And that also is some sign that they are feeling pain. Now, I think one of the areas where this discussion often takes a wrong turn, and I have been guilty of this myself, is by putting it as we're going to see the science will show us whether somebody is really in pain. That this is the definitive signal that this MRI equals pain, absence of this MRI equals no pain, period, end of story. That may occasionally be true, but I think much more likely it will be a piece of correlative evidence when we see this pattern in ecologically similar circumstances. 90% of people report that they're in pain. When we take people who report they are not in pain, we only see this 1% of the time. Things like that, showing correlations less than 100%, are going to be the kinds of evidence this is. And in a sense, I think that's a useful way of thinking about it because it takes it away from this magic, perfect mind reading and puts it back into the real world of mind reading. I'm reading your minds, but I know I'm not all that good at it. If we were really good at reading minds, poker wouldn't exist, and dating would look a lot different. So we all read minds all the time. We're not very good about it. We know that. Neuroscience, neuroimaging will read minds too, already can read minds, but we shouldn't expect it to be perfect, at least not very often either. And actually, this is one of the areas where the fact that I work on genetic stuff helps. People used to think genes equal destiny. You've got this gene, you're going to die. Well, you are going to die eventually, but you're going to die of this. And I think part of that was an ascertainment bias problem. The first things we saw, because they were the easiest ones to see, were the most powerful, the most deadly, the most penetrant. And so we got this feeling that genes were always destiny. And it turns out genes are occasionally destiny, but most of the time, they're a thumb on the scale. They move you from 15% chance to 25% chance or to 5% chance, or more often from 15% chance to 16% chance or 14% chance. The neuroimaging evidence is going to be similar to that. There will be times when it is like Huntington's disease and it's 100% penetrant. So I have a strong suspicion that if you had somebody in a scanner whose visual cortex was completely gone as a result of stroke or tumor, that you could pretty confidently predict they couldn't see anything. Even if their eyes were in perfect shape, without the visual cortex, can't see. If you took somebody who was not able to make words, was making noises but not with any really good discrimination, and you put him in a scanner and you saw that he'd had a big stroke about here in the Broca's area of the brain, you'd say, that's pretty good evidence that he really can't talk because Broca's area is about, or one of the things that in almost all of us is specialized for doing, is helping us articulate sounds. It controls the voice box and the tongue and the other things that actually make the words we speak. So there'll be some areas where neuroimaging will be really, really strong at telling you what's really going on. There'll be others where it will be weaker. Most of them, I suspect, because that's the way the universe seems to be set up, will be the weaker ones rather than the stronger ones. But they will still provide some evidence. How good that evidence will be is a different question. How we might want to use that evidence, though, is what I want to turn to now. How could the law use neuroimaging mind-reading evidence? Amanda, in a recent piece, has pointed out one good way for the law to use it to help understand better some of the processes going on. So you might use a lot of neuroscience to help jurors or administrative law judges or even real Article 3 judges understand better. I'm sorry, I didn't mean to dump on Article 1 judges. Even Article 3 judges, however real they may or may not be, to understand better what the science actually says and what these things really mean. And that's one use. Another use might actually be, in some ways the most obvious, communication. You might be able to use this to communicate with people you can't otherwise communicate with. There is an amazing example of this in the research that's been going on for about 4 years now, involving people who are apparently in a vegetative or a minimally conscious state. These are people, those in the vegetative state, it's defined as they are clinically unresponsive. You can't do anything at the bedside that gets that draws a response from them. They may move and see, and their eyes may move, they may roll, they may make noises, but they're not in response to anything. And some researchers led by Adrian Owen, now at the University of West Ontario, and Stephen Lauries at the University of Liège, took 54 people who came in either in this most serious vegetative state or in this slightly less serious, 3 minutes a week they managed to respond, minimally conscious state, put them in scanners and talk to them. And they did things like say, think about playing tennis. You're on the court, the ball comes, you hit it over the net, gets hit back over the net, you hit it over the net, et cetera, et cetera. Or think about walking through your house. You come up to the front door, you open it, you enter the hallway, you walk into the living room, you walk into the dining room. And what they were doing was looking for, they did this when people were in the brain scanner, in the MRI machine, doing an fMRI analysis, looking to see what areas of the brain were working when they were told these things. Specifically, for the walking around your house, they were looking at the parahippocampal gyrus, which is an area that is often activated when people are doing navigation tasks. And for the tennis, they were looking at the secondary motor area, which is often activated, maybe always, but certainly often activated when people are thinking about making motions. 49 people, they got noise. 5 people, with the tennis playing scenario, they got activation in the secondary motor area when they were talking about tennis. 4 people, and all those 4 were among the 5 who responded on the tennis. 4 of them, when they were doing the navigation task, they got activation in the parahippocampal gyrus. These were people who had not been responding to anything, but their brains were responding to being talked to. Now, that doesn't mean they were conscious. I believe, although I can't prove this, that when I'm sleeping, my brain makes a distinction between hearing a siren in the distance and hearing, when I was younger, when my kids were younger, hearing a baby cry. I'm asleep, I'm unconscious, but I think my brain still is paying some attention. But they took the experiment a step farther. They took a guy who had been diagnosed as in a vegetative state, persistent vegetative state, for over 5 years. And the other thing this group is famous for is distinguishing between minimally conscious state and vegetative state. They're the world's best at saying, you called this guy vegetative, but he's actually minimally conscious. They said this guy had been in a vegetative state for 5 years. They did these same tasks, but this time they asked him questions. First, they did it with 16 normal people, and the normal people got them all right. They do it with this guy. Was your father's name Alexander? If the answer is yes, think about playing tennis. If the answer is no, think about walking through your house. Do you have any brothers? If the answer is yes, think about walking through your house. If the answer is no, think about playing tennis. 6 questions. You got the first 5 right. No response on the last one. Why? Well, we don't know. Did he fall asleep? Did he get bored? Was it ambiguous? Did he think, well, I'm not sure? We don't know. Right on the first 5. That's mind reading for communication purposes. You could imagine that. Have to be, I think, better. You need more than an N of 1 demonstration, and there have been some more. They just had a recent exciting paper about using PET scanning rather than fMRI to do the same thing. You could imagine that in court, or you could imagine that in the hospital or in the rehab clinic as people are being asked, whether they're in pain, how they want to be treated, et cetera. That's mind reading with a potential legal connection for communication purposes. But fundamentally, the biggest use of mind reading in law will be de facto lie detection. Not necessarily frank lie detection, but if you say, "Are you in pain?" and you say, "Yes, I am," why would you test him with any other way to see whether he's telling the truth or not? Now, this isn't odd. Police officers could stop somebody who's weaving in a car and say, "Are you intoxicated?" And you say, "No, of course I'm not, officer." And we could take their word for it, or we could give them a breathalyzer. The breathalyzer there is serving the function of a lie detector in a sense. It is giving us additional evidence to their own self-report. Similarly, doping tests in sports, or law school exams. I just finished grading 64-hour essay tests for property, and I will recover, I'm sure, in a few months. Why did I do that? I could just ask my students, do you understand the course really well? Well, not so well, terribly, and just assign them grades based on that. But I don't. Although it's actually today, it's really tempting because I finished at about 2 o'clock in the morning today. So it sounds better today than usual. We do those sorts of checks, and they're effectively lie detection. Pain detection could be useful for people or even non-people who you can't ask, who can't communicate with you. But it could be more useful to see whether somebody who says they're in pain is showing the signs through neuroimaging that correlate with the existence of either acute or chronic pain. My colleague at Stanford, Anthony Wagner, works on memory. He did this great test where he took a bunch of the usual subjects, undergrad psych majors. We know almost about them, as much about them as we do about rats at this point. And both are about as similar to the rest of humans as each other. Undergrad psych majors, showed them 100 pictures, 5 seconds to look at each, said, try to remember these faces. These were faces. Put them in a scanner, showed them 100 faces. 50 were from the 100 they had seen, and 50 were different. And he asked them, push the button one way or the other if you recognize or don't recognize the face. He was able, using the scanner, to 86% of the time or so, tell whether they recognized the face or not, regardless of what they said. He was able only slightly, 56% accuracy, to say whether they had really seen the face before or not. That one he isn't ready to count as a win yet. But whether they thought they recognized it, he could show with the scanner. Is that important? Well, think about a test where you take a defendant and you show him pictures of the crime scene that haven't been publicized, and you see whether his brain recognizes them or not, whether he has a memory of it or not. There's a similar kind of technique using EEG, electroencephalogram, which has many advantages, particularly being cheap and portable and easy, looking for something called the P300 response, which appears to be a response you get about 300 milliseconds, it's actually like 280, I think, after a stimulus that is correlated. People initially thought it was correlated with memory or with recognition. It looks more now like maybe it's correlated with salience. You see something that you think, that you pay attention to, which can in turn be correlated with it's because I've seen it before. So there's a guy named, this whole field, this particular thing got a really bad name. It's sort of an interesting side note on the sociology of science. The first person to push it was some people would call him a crank. Others would call him a quack. A guy named Larry Farwell, who's formed a company called Brain Fingerprinting and grossly oversold this. The fact that he also talked about being able to levitate himself with respect to transcendental meditation probably didn't help his credibility. Although that's the kind of ad hominem issue you really shouldn't take into consideration, I guess. I'm not sure I have the free will to ignore that. He gave it a bad name. There's a guy named Peter Rosenfeld at Northwestern who's been working very hard on it, along with a lot of other good researchers around the world. He published this really interesting study. Again, it's with undergrad psych majors, so discount it for that. Showed them pictures showed each of them 3 pictures. And the idea was this is a terrorism scenario. Showed them a device, either a bomb or a propane tank or something that looked like it would hold a biological weapon. Showed them pictures, an iconic picture of a city. So the skyline of Chicago, the Golden Gate Bridge in San Francisco, et cetera. And then showed them a kind of location, a sports arena, a bank, a school, or something. Each one got one of each. So You know, it was the old game of Clue. He did it with a propane tank in San Francisco in a bank, right? Then showed them pictures, looked for their P300 reactions, and he reported that with over 90% accuracy, he could tell from their reactions which ones they had seen. Again, some potential legal applications, perhaps. And then there's frank lie detection, where people claim to be looking for deception itself. This has gotten an awful lot of attention, including from me, mainly because there were two companies that were selling this in the US. Since 2007, I am kind of happy to say there's now only one. One of them has dropped out of the market. The bad news is it was the less irresponsible one. CFOS, headed by a scientist. The one that's still in the market is the too good to be true, must be fiction named No Lie MRI, whose site will fill you in on all the potential dating uses of their $4,000 fMRI lie detection. So I am fairly skeptical about, frankly, detecting deception at this point. But I have to say there are 30 peer-reviewed studies, all of which have found statistically significant correlations between patterns of brain activation and when somebody is lying. My biggest problem with them is they are almost always undergrad psych majors, right-handed. The No Lie fMRI is based on 4 Penn undergrads, right-handed males who claim that they never use drugs, so we know they're lying to begin with. But it's not, how relevant is that to when you say on the stand, no, I didn't buy cocaine from that officer? And how relevant is it to people who aren't male undergrads who are right-handed? As somebody who's mainly left-handed, I take great solace from the fact that all the studies have been done on right-handed people. How relevant is it in a wider world? We don't know. But I'm agnostic. I'm not negative. I think this may turn out to work. Between pain, memory, recognition / salience, frank deception, and there are others out there. Somebody at a trial says, I feel great remorse for what I did. Well, I don't know that we can do this yet, but it wouldn't surprise me if we could see remorse, or at least strong emotion, find brain patterns of activation that correlate with a feeling of remorse or a feeling of strong emotion. People oversell this, they overhype it. People claim that any sort of activation of the amygdala means all sorts of things, but it turns out it does mean all sorts of things. The amygdala activation shows up in lots of different circumstances. It doesn't always mean fear. But we may get better at it and be able to say this kind of activation almost always means somebody's afraid, or somebody's excited, or somebody's hungry. I don't know that we'll get to the stage of saying, Mark really wants that bacon cheeseburger with the guacamole on the side, but that Mark is hungry. I bet that's not too far off. So you can imagine, say, the emotions being used occasionally in court. And then I'm talking about court. Court is the most dramatic stage. That's why it's used in stage and screen so often. But the law is far beyond court, certainly far beyond trials. Sentencing, really important. Much lower rules for bringing in evidence. Police investigations, deciding who to go after and who to charge, an important part of the legal system. Or for that matter, what the legal system says about letting people in the world use this. Can employers use this on you? Well, that's kind of a legal question that the legal system will have something to say about. Can adults use it on unwilling teenage children? I tell you, I like to think I wouldn't have. But there were times when I would have loved to have a lie detector on my teenagers and say, were you really studying? Put it on the headphones, play their favorite music, ask them the question and see the results. It'd be tempting. And actually, we got very good friends who had a son get into meth in high school and several involuntary commitments, suicide attempts. It's been straight for 5 years, look like things are working out. But I wouldn't have judged them harshly if they'd done something like that. So should the law allow that or not? Another legal system question. The legal system is much more than a trial. Okay, category 3. If we want to do this, how are we going to do it well? We know we can do it poorly. We were really good at doing things poorly. And to the extent it's been done so far, I would say, or sought to be introduced, I'd say it's often been sought to introduce, done poorly. What would you need in order to make this useful evidence on which we could have confidence? I would say it boils down to two things: science and systems. You need the science to know just how good these correlations are. You need studies on more than 4 Penn undergrads. You need studies on hundreds or thousands of people. You need studies on young people and old people, men and women. You need studies on people who've taken drugs and those who haven't, people who are currently taking drugs and people who aren't, on people who've had mental illnesses of various sorts. Whether it's pain, whether it's deception, whether it's memory, you need to know that you've got a wide enough sample of the world. You also probably need to come up, and this is very, very hard from a research ethics perspective, with ecologically realistic studies that aren't undergrads who signed a form and know they're getting paid $50 and are, quote, lying, close quote, because they're doing what the investigator told them to do. If you see the 8 of spades, say you don't see it. Is that like saying to the officer, no, I didn't say it on the stand, no, I didn't try to buy cocaine? Is that like me saying to my mom, no, the turkey was perfect, it wasn't too dry? It might be, it could be, but we don't know. And designing realistic experiments is going to be tough because you can't just, at least here, round up a bunch of undergrad psych majors and throw them in jail and make them really think that they're going to get out or not get out depending on whether they fool the machine. So lots of studies. It would help if we had a really good predictive set of theories on which those studies could be based. And we're kind of getting there, but I think it's more, again, to go to the genetics analogy, it's more like looking for genetic correlations with diseases. You got a few theories, but for the most part, you look at a bunch of people with diseases and without, and you look at what genetic variations they have and don't have, and you start correlating and see what you find. Maybe someday we'll get beyond that with, say, drug discovery. We're doing a little rational drug discovery now, but we're still doing an awful lot of random drug discovery. So science to tell us just how good these correlations are. And much of the time, and maybe for all of this, maybe it'll turn out there are no useful correlations with respect to pain and neuroimaging. I think that's already proven wrong. But maybe the correlations that exist aren't strong enough to be useful. Or maybe, another scientific subject to explore, maybe they're easy countermeasures. Anybody here ever have a kidney stone other than me? Yeah. Fun, wasn't it? Yeah, so one of our co-sponsors here who runs the Center for Advancing Research, Chronic Pain Research. Okay, newly named. We were talking about it at lunch, and he said, well, that's when I first realized what a 10 is on a scale of 1 to 10 of pain. Kidney stones really hurt. I've had them twice. I remember it. If I'm in a scanner and I'm trying to pretend that I am feeling back pain, and I remember in vivid detail my kidney stone, what will the scanner look like? And I don't know the answer to that yet. My friend Sean Mackey at Stanford is actually trying to do some of those experiments. But that'll be interesting. You have to worry about countermeasures. Because if they're good countermeasures, no matter how good the science is, the countermeasures make it not very useful. So you need to do a lot of science. And I mean a lot of science, and with big N's. One of the real problems with most neuroimaging, because fMRI is expensive, is that the N's are small, typically. 10, 20, 30 is a big N. I'm talking hundreds, if not thousands. The second thing you know, though, you need is even more important, and that's systems. You need protocols, you need accredited labs, you need people who do the same thing according to a manual, by the book every time. There's been one appellate decision about lie detection in the United States, fMRI-based lie detection, US v. Semrau. The district court magistrate then, now district judge, did a wonderful job in his opinion, which the appellate court, the Sixth Circuit, largely affirmed and largely adopted. And one of the big complaints was they kind of made it up as they went along. They got a good result in the morning, a bad result in the afternoon, so they decided, well, maybe he was too tired in the afternoon, so they did it again later. And that doesn't lend itself, that doesn't give you a lot of confidence. So here's my precedent for what I'm calling for. Probably the most successful innovation in scientific evidence, certainly in the criminal world, in decades, forensic use of DNA. It's not perfect. Sometimes mistakes get made. Sometimes there's contamination, sometimes maybe even OJ was innocent. Who knows? Maybe the detective did plant the DNA, although I can't believe it, but maybe he did. And of course, the mere fact your DNA was there doesn't mean you were guilty necessarily. So it's not determinative, but it's pretty good evidence. I remember the early 90s when DNA evidence was first sought to be introduced. It was really controversial on lots of grounds. One of them was defense attorneys hated it because they thought they would lose a lot more cases. Later, they turned a little bit because they realized they would get a lot of their suspects dismissed for not being a suspect, not being the perpetrator. But both of these stages were important. There was a huge fight over population genetic statistics. Would the CODIS markers that they used have really different frequencies in different human populations? So yeah, you're using this thing with European Americans, but maybe it looks really different with Asian Americans or African Americans or Native Americans, or maybe Navajo look a lot different from Hopi. National Academy of Sciences did a report. National Academy of Sciences, if you've got several $1 million, is a great place to get a nice scientific report out of. They did a report and they said, this is a real issue, and we should worry about it, and in the meantime, we should take a very conservative view. 4 years later, a couple more million was found. They did another report, and they said it's been solved. You know, the science has moved along far enough that we can say with confidence that there are interethnic variations, but they're relatively small. And it may make a difference of 3 orders of magnitude, but if you're moving from the quadrillions to the trillions, it really doesn't make very much difference. So the science was done to make this more usable. But the other, I think, bigger thing that happened was the FDA started accrediting crime labs to do DNA work. With manuals and with inspectors, it doesn't mean it's perfect, and every once in a while, unfortunately, you still get corrupt directors who are indicted for doing all sorts of terrible things. But it's made it a lot better. There are procedures that have to be followed. And the procedures, of course, are to some extent bureaucratic and mindless, but to some extent really help give you confidence in the standardization of the result. So if we want to move any of this neuroscience mind reading into the courtroom, I don't think it's something of a couple of researchers getting an R01 and a lawyer or two for the plaintiff's bar picking up on it. I think it's a big project. I think it's multi-millions of dollars for the research and for the lab standardization. It can be done, and it was done with DNA, and it was expensive. DNA had the advantage that the underlying scientific theory there, at least with respect to identification, was really solid and really easy. And there's not going to be anything I think as solid or easy in neuroscience. But the hard work of doing this can be done. It just takes money, and will. And it takes more than the occasional grant from NIH, which isn't all that interested in it, or the National Institute of Justice, which is barely interested in it at all. The intelligence community is very interested in it, but they won't tell us what they find, so it doesn't much matter. Or they will, but they'd have to kill us. So what are the problems? Money in politics. There is, I think, the chance for money for some of this. Pain is a big deal. Pain is hundreds of thousands of cases a year in the United States. Court cases, but overwhelmingly Social Security disability cases. And we know that sometimes things are wrong. And people who should win lose, and people who should lose win. Getting it better, having a good test, not only gives you better results if your test is good, if it's helpful, not a perfect test, but adds to the value, adds more value to all the other things you do. It not only gives you better results, but it should also prevent more of those cases from going to trial or going to hearings, because the better the information going in, more often the lawyers are going to say, let's settle, or let's fold, or let's say yes. So I think the potential is there, but who would do it? And here's sort of politics. I could imagine insurers doing it, or state disability people doing it, or the Social Security Administration doing it. And I could imagine on the plaintiffs and consumer sort of side a reaction that anything they do has to be wrong. So coming up with a source of funding that is politically neutral, enough to be accepted and acceptable, is a challenge. But I think it's an important challenge. And frankly, I don't see it happening now. I think the use of neuroscience mind reading in courts is going to be slowed not so much by the lack of science itself, but by the lack of a plan and a program to get the science into a state where it can be well used in court. And I think that's something we need to concentrate on. Last point. Let's say it all works. Right. But let's pretend, right? Let's dream and say that somebody comes up with $20 million over 4 years, and we figure out something that gives us, positive predictive values of over 90% with respect to whether somebody's feeling pain or not, negative predictive values of over 90%, not 100%. Amanda could be that one really, really rare person. Her brain shows she's not in pain, but that's just because she's got a really solid brain, an unusual brain, which we knew anyway. And the other evidence should be, you shouldn't use this as a trump card. It's one piece of evidence, though depending on how strong the correlations are, it's a stronger one or weaker. Let's say it works. Are there still problems? And I think there still are. Going to an issue that my friend Nita Farahani has written about or is writing about and calls cognitive liberty. People also think about it as mental privacy. Is reading your brain different from a blood alcohol test? Is it different from watching how you walk? Is it different from what you say? Is it invading something secret? Now, of course, I hate to use this example in some ways because my mom's turkey is never too dry. But if she were to if by some odd chance, some Thanksgiving, the turkey was too dry and she were to ask me, as she always does, is the turkey's too dry this year, isn't it? And it actually were, I would lie, happily. And if I couldn't do that, that ability to keep your thoughts to yourself feels really important. If you are in, say, the Democratic Republic of Korea, and someone puts you in a scanner and shows you pictures of, I think he's the dear successor this time, the great leader, anyway, of Kim Jong-un, and then shows you pictures of the president of South Korea and, say, pictures of President Obama, and wants to know your reactions to them, you'd kind of have both instrumental and non-instrumental reasons to hope that you might be able to keep, some people might want to keep their true feelings hidden. That ability to hide, we have. The law can, quote, force you to testify and force you to tell the truth, but it can't force you. It can throw you in jail for contempt if you refuse. If you've got the Fifth Amendment, but even if the Fifth Amendment doesn't apply, let's say, because you've been immunized, we can't really force you. We can torture you. We can't, well, let's not go there. One could be tortured in some circumstances. That may or may not get you to tell the truth. Often, apparently, it gets you to tell whatever you think the torturers want to hear. So we've got that for technological reasons, really, we have that special preserve that can't really be invaded. If it could be invaded, should we allow it to? Or should we say, no, can't do it? If it's involuntary, and I'm tempted to say, no, you should never be able to do this to somebody involuntarily, but then I think of sort of the 24-hour scenarios, which are a dangerous way to think, but maybe there are times when it might make sense. Quasi-involuntary. You want to bring a lawsuit, you want to bring a suit about pain, the other side wants to read your mind about pain. You don't like this mind-reading stuff. You are in pain. You're not, but you just don't want to do this. You could avoid doing it, but it may well mean you lose your case. You refuse to submit to a medical exam that's ordered by the court. You can do that. Your case will be dismissed. But you can do that. That's sort of quasi-involuntary. And then truly voluntary. What if we only let people do it who truly volunteer? That seems fine. Except if you allow anybody to do it voluntarily, what does that mean for the people who choose not to do it, innocently or guiltily? It means, ladies and gentlemen of the jury, Professor Chandler here could have taken that lie detection test, but she chose not to. That is her right, but it is your right to draw whatever conclusions you want from it. Now, you can't do that with the Fifth Amendment assertion in the United States, in a criminal court, in the federal level. You can in some states in civil courts, however. Would this fall under the Fifth Amendment? I don't know. But allowing anybody to do it voluntarily puts pressure on everybody else and makes their decisions less voluntary. And I think these are going to be, assuming we see through scanners less darkly and more clearly, these are going to be the deepest questions we're going to have to answer. These will be useful technologies. Are there limits to when we think they should be used in protection of people's right, if they have one, to some kind of mental privacy? And if we do think there should be a right to mental privacy, where do we find it? First, third, fourth, fifth, sixth, seventh, eighth, ninth, and 10th Amendments? Throw in the second, too. What the heck? Is it in a penumbra? Is it in a shade of a shadow of a penumbra? Do we need new legislation? Do we need a new constitutional amendment? Maybe. So, in conclusion, the two words every audience most loves. I think we live in interesting times. They're getting more interesting. All of this is a secondary use. My friends, the neuroscientists, are not getting a bunch of money to do pain detection for court purposes. They're not getting it to do lie detection for criminal justice purposes. They're learning about the brain, mainly funded by the National Institutes of Health, not the National Institute of Justice, because we want to relieve human suffering by learning more about how the brain works and how we can affect it. But as we learn more, and we will, I think, I hope, I believe, make good inroads against human suffering through this kind of research. But as you learn more about the brain, what you learn isn't necessarily limited to only that kind of use. Just as biological research can help biological warfare, not that this is biological warfare, but more knowledge about neuroscience and how human brains work can lead to other applications of that knowledge for things like mind reading that have their pluses and have their minuses. I think our goal needs to be to pay enough attention, to become educated enough to think and worry about it enough, that when it happens, we'll be able to respond in a more intelligent and useful way. I used to say, I do the work I do in the hopes that these new technologies, and all technologies can be used for either good or ill. The plane that brought me here last night, I think, was a good thing. You may not agree. The 9/11 planes, that was a bad use of the same technology. All technologies can be used for good or ill. I used to say, my goal is to try to maximize the benefits and minimize the harms. I've become more humble. My goal now is, I hope that if we alert enough people and we get them thinking enough about this, we can avoid a few catastrophes. And avoiding catastrophes, I think, is a good thing. So I charge all of you, go away from here thinking about, paying attention to, keeping your eyes open to the possible beneficial and less beneficial uses of neuroimaging and neuroscience in the law for mind reading. Thank you very much. So Diane, do I get the wine yet? I think I've cleverly left, actually, usually I try to use up all the time so I don't have to face any questions, but unfortunately, I've left some time for questions. Yes?
So I have a wonderful lecture, and I was just wondering, in terms of a worry that was raised to me by some of the examples you gave, that
Yeah.
reminded me of some work by Rome Lecture called Big Bad Data.
Yeah.
Let's say that they're trying to create a database of people who are really, and your focal state of the really in pain person, say the example you gave, the one with the bone sticking out of their arm.
Right.
It seems to me that if that is your focal group that you match people up to, or if you have other groups, my worry is that you're going to be biasing the initial data
Yeah.
in predictable ways.
Okay.
And it almost raises questions for me like physical versus mental health.
I agree. So I think you need to avoid having a focal group. You need to think about different kinds of pain as being different potential populations. And of course, if you've now got 10 different kinds of pain you want to explore, you've just increased the cost of your research by an order of magnitude, which is going to be a problem. But I think you have to, monism is really attractive and really dangerous, to think there is one kind of pain or one kind of this or one kind of that. On the other hand, one of the interesting things about some of this research is maybe different kinds of pain actually look more alike than we think. There's a story, this article, 2003 now, I think, in Science, about social pain that lit up some of the same areas that seem to be lit up with respect to more traditional physical pain. And that has some potential legal implications too. We've tended to downgrade pain and suffering or emotional suffering as a source if, in fact, neuroscience gives us reason to think that they are more similar than we thought before. One way of looking at that is it causes problems for figuring out what pain really is because you've got all this social stuff mucking up your thing. And another is, well, you know, maybe we shouldn't make that division at all. So this is much easier to say than do. I think you need to go into it with a somewhat agnostic, searching, uncertain view of how many categories you're going to have. You have to start with some idea of categories, but you have to be willing to either collapse them, make them bigger as you go along and as you learn more. But the idea that maybe there is only one kind of pain and it has one kind of signature, I doubt that. And we need to make sure that whoever's doing this work avoids that. I do hope that one of the products of law and neuroscience will be enough neuroscience literate lawyers on the other side so that the adversary system can do some of the work we need to do there. Yes? I think she wants you to speak into the microphone, sorry. So the NSA can get an even easier recording of you.
So let's say that you're correct and we get to a 90% confidence level.
Let's say that my dream was right, okay.
Then what happens to education of juries?
Yeah, great point. I think and so part of that is the job of the lawyers on each side. Lawyers are some mix of theatrical directors and educators, at least in jury trials. They're each trying to put on a play at the same time, but one that has a different outcome. And they've got to deal with this other director who's trying to make it come out the other way. But the other thing they're trying to do is educate the jurors, and when they think they have a chance, even educate judges to understand what's really going on. That was for my friend Andre. I think you would want, if both sides had good counsel, you would hope that the counsel would educate them about the limitations and advantages of this, the pluses and minuses. Both sides won't always have good counsel. Maybe it should be the case that jury instructions need to be written more carefully to explain some of this stuff. I do think this is going to be, at least in jury cases, not that judges are perfect and juries are awful. I think judges are likely to be somewhat better than juries in this. It's going to be uphill because we know that most people aren't real good at probabilities. I mean, the lottery flourishes, so we know people aren't good at probabilities. And all this is going to be probabilities. Educating the jurors is going to be a problem. Educating the judges is going to be a problem, but there are fewer judges, and there are programs like one Mark runs at AAAS that aim to educate judges, particularly right now on issues around neuroscience. So yeah, I do think it's a concern. One of the things I've written recently that I'm most pleased with is a piece I wrote with Anthony Wagner, the psychology department at Stanford, for the reference manual on scientific evidence for the federal judges. We did a chapter on neuroscience, and that seems to me a really potentially force-extending way to write. Instead of a normal law review article where maybe my research assistant has read it if he's telling me the truth. You know, I think a lot of judges who face these sorts of questions where they feel completely at sea, and lawyers trying to influence the judges will read that. So education, important. Education of the juries, I think usefully done. One would like to think the lawyers will do it. They may need some help. I think in the pain area in particular, ALJs, administrative law judges, in the administrative, in the state disability and Social Security and workers' comp, they have huge power, and my guess is they could use some more education about this. And education in both sides, both that says, here are some of the things that might be useful for, and education that says, don't get too excited about this, here are a bunch of problems as well. But of course, I'm a teacher, so education's always part of the answer, right? Yes? I'm sorry, Sorry, Bob. You're next.
So as
Unless
you
the wine
mentioned,
gets too attractive.
as you mentioned toward the end, scientists tend to like to understand mechanism.
Yeah.
They like to understand how the brain works.
Yep.
Or what
Would
goes
like-
wrong, and
would
what
like
goes
to
wrong in
understand it.
disease states.
Yep.
But I was thinking to validate imaging as a tool for lie detection or mind reading,
Yep.
should we kick the scientists out of this entirely and just do a massive global correlation, as many people and as many thoughts as possible, bring in the engineers and the statisticians to organize the data? And will that be even a more effective way of getting to the goal?
So I wouldn't kick the
Understand-
scientists out, but I do think you're absolutely right. The scientists I know are really interested in causation and why things are the way they are. And you know, it's one of the advantages of the legal system here. We don't necessarily care. If every time you see X, you will definitely see Y, you know, we could use X as a marker from Y without having a clue about why that's true. Now, the better clue you've got, the more confident you might be that every time you see X, you will see Y. But we don't need that. If the correlations are strong enough, we don't need that. I wouldn't kick the scientists out. I think they know a lot that would be very useful. But I do think that the kind of project I have in mind would not, although it would provide data very useful for a lot of scientific explorations, it would not be fundamentally aimed at answering the questions that the scientists would be most interested in. And that's kind of a problem for doing science. That was one of the problems argued against the Human Genome Project. You know, we don't want geneticists working on sequencing yeast. Who cares about that? We want them doing important, interesting things. This will be mindless work, and it'll turn out a generation of mindless, gel-running graduate students. These arguments were made, and they were not entirely false, but they also turned out not to be entirely true either. So I do think that the focus of this would have to be more on finding useful correlations and less on the kinds of deeper scientific understandings that many of the scientists would want. I do, however, live in the hope that we could make it win-win for both sides. Karen? Oh, no, Bob, my law school classmate,
Yes.
although somehow he's now 20 years younger than I am.
Well, I did start as a child, but so I was wondering if,
And his wife, another of our law school classmates, I'm sure is 40 years younger than either of us.
and the longer we go, the more distance there'll be. So I wonder, as you were describing this, one of the things that was coming to my mind is the way the law struggles to determine responsibility, whether it's in criminal law or tort law. Not only what did people do, but are they responsible for what they did? And so some of what's interesting to me about the neuroscience is almost taking that out of the equation, that it's happening whether you are causing it to happen or not, which may not be a necessary part of what you're saying, but is kind of where I think maybe juries and judges might kind of run to. So, and which is just a setup for asking about whether you or others working in this area have looked at the whole implicit bias literature, because again, what's so interesting about that is you may act at the explicit level of not thinking you're prejudiced in any way, and then they do these tests which show that actually, without your knowing it, you are responding in a way that would suggest that there is some deep prejudice. And then the question is,
Right.
What's your level of responsibility for that, other than awareness that maybe going forward you need to change your behavior?
So were you a philosophy undergrad?
History.
Okay. I mean, the responsibility questions are very attractive to lots of people, and I do think the neuroscience project writ large will cause people to ask lots of questions about responsibility. I think this particular corner of it less so. I'm looking to identify, I'm looking at things that might help identify what your mental state is now. That could be a mental state that would absolve you of responsibility or convict you or give you responsibility, but oftentimes it won't have anything to do with responsibility at all. The IAT, the implicit, implicit associations test, is interesting, has been looked at. There's a neuroscientist at NYU named Liz Phelps who's been doing interesting work trying to correlate fMRI studies with IATs. What she really wants to do is correlate fMRI studies with bias, but it's really hard to get subjects who will admit that they're really biased. There is still a lot of controversy, as I understand it, about how good the IATs are as a marker of bias or as a marker of bias that gets acted on. But I do think it's an area people are thinking about and should be thinking about.
there are people who can fool traditional lie detector tests.
Yep.
And these studies we're talking about aren't, we're not asking the people to fool the MRI or fool the scientist, right? What do you do with these people who are able to fool these tests? They can have so much control over their brain in a
Right.
way that they can override any of the science.
So we do know that there are both people who seem to be able to fool lie detector, the traditional polygraph, which is measuring physical attributes that are correlated with nervousness, actually. And the theory is light is correlated with nervousness. Nervousness is correlated with sweaty palms, with increased respiration, increased blood pressure, etc. There are also people who can learn tricks that will help them do that. Things like hiding a tack in your shoe. And when you're asked the control questions, so they ask simple questions and then they compare your response to questions they think you're going to be nervous with. You put your toe on the tack and you get the same kind of polygraph responses that if you're really nervous about something, bad things happen. So they're both learned ways to beat the polygraph, and there are people who seem to be able to beat it without knowledge. Whether that will be true with respect to other kinds of studies, I think other kinds of methods will depend. And you'll have to look at it for each method and for each kind of application. I think the study of, for any actual broad application of this, the study of countermeasures is more important, is as important as the initial study. And some people have been doing that. There's a guy named Giorgio Gaddis at Harvard who did a countermeasure study on the fMRI lie detection stuff. He did a simple lie detection, 10 subjects. He was 10 for 10 and figuring out when they were saying what wasn't true because they'd been told to say it wasn't true. And then he had them do, and I think it was mental arithmetic. He had them do some sort of think about something distracting when they were answering the question. And his accuracy went down to 3 out of 10. So he didn't even need a tack in the shoe, which presumably you could look for. He was having them do something different with their minds. Rubenfeld Rosenfeld at Northwestern, I give him big credit on his guilty knowledge test EEG stuff with the P300 because he's actually got out of his way to publish countermeasure work, both showing that there are countermeasures and then showing that he's got ways to avoid those countermeasures. The last time I talked to him, he had a grad student he was very excited about who'd come up with a countermeasure to beat his countermeasure beating method. So it will probably be a dance, you know, a Hegelian thesis, antithesis, synthesis that goes on forever. But I do think it will have to be looked at for each modality, for each technology, and maybe for each kind of question. Maybe people will be able to beat memory detection but won't be able to beat pain detection. Or maybe they'll be able to beat pain detection but won't be able to beat, maybe they'll be able to beat the fMRI but not the EEG. So I think it's an open empirical question and one that, again, if you want to do it on the cheap, which of course we always want to do, those are the things that likely will get cut out and they can render your results accurate enough to be published and not only inaccurate enough to be useless, but inaccurate enough to be dangerous. And I think that's quite a note to end on. Let's go have some wine and be dangerous.